All right, well, good morning, everyone. Thank you for joining us for the third in our webinar series. We've been overwhelmed by the responsiveness of everybody who wanted to participate, the questions that have come in. We're incredibly thankful for all of you to spend this time with us and make this a truly successful platform to share some ideas. I can tell you as a firm, we're actually thinking how great this was. We're looking to expand this program. And please look forward to seeing something about that in the coming weeks, where we'll be maybe taking some more current events and discussing those topics with this audience and allowing you an opportunity to chat amongst yourselves and ask our lawyers any questions you have. So today, once again, we've got Stacey and Len are going to be presenting on doing the virtual assessments, and Matt will be answering any questions for you that come through on the Q&A or through the chat. We will not be doing a presentation. This is just meant to be 30 minutes of us discussing these topics with you and trying to answer as much as we can. This session is recorded. As in previous times, anyone who is registered will get a copy of the session along with any additional questions and answers that we can come up with for you. We'll try and get that out for you as early as we can, probably early to mid part of next week. With that, I trying to give it over to Len and Stacey. Thank you, everybody.
Thanks very much.
Thank you.
And, thank you all for joining us. As Mark said, for the third of our webinar series, and this one is entitled Best Practices for Reporting in a Virtual World. As you know, we've discussed a couple of other issues relating to healthcare practitioners practicing in the current environment, and we'd like to talk a little bit today about reporting and what we've learned from speaking to insurers and dealing with insurers over the last few weeks during the COVID-19 crisis. So Stacey, you want to start us off on this topic?
Thank you, Len, and welcome everybody. Happy Friday. So we've had it, as Len said, we've had a chance to talk to some adjusters to get their view on reporting and what they would like to see. And it varies from adjuster to adjuster. So I think the best advice that we have to offer right now is that in terms of updating, which seems to be the biggest complaint that we're getting, is that they're not getting updates as often as they'd like, especially with the whole COVID situation. So I think at this point, it's probably best to give the adjuster a call or shoot them an email and just find out what their preferences are. And I don't think that they're expecting everybody to just start sending in updated reports, because everyone understands that there is a cost perspective to that for you. We know that there's only a certain amount of time that's been allotted in your treatment plans for reporting. But a quick phone call, a simple email update, just to let them know what's going on, especially in cases where the client is deteriorating and you're asking for some extraordinary things. For example, if your client is struggling now that they're at home all the time, let's say they're working part-time, but they still have some issues and they need some ergonomic equipment for their home office setup, or to deal with computer issues for the people with brain injuries who are socially isolated. A quick phone call, an email to the adjuster to start off with outlining this is probably in the client's best interests. Len, have you got anything to add?
Yeah, I would just add to that some adjusters have said to me that it helps them to be getting more reporting during this time period, because they're working from home as well, and it helps them show their supervisors that they're actually keeping their files moving and they're working. So my experience has been a lot of adjusters want more reporting during this time period to help them, show that they're continuing to move the files along and that they're continuing to work. So I think Stacey's comment about calling the adjuster, getting their preference, and working with the adjuster in terms of how frequently they'd like you to report is an excellent idea. The other thing that I've heard from a number of adjusters is that they actually have more time on their hands. They don't seem to be in such a crush as they were when they're working in the office. They've had more time to deal with the files, more time to deal with expenses. So for those healthcare practitioners out there that help your clients in submitting expenses. You should try to do that as regularly as possible, because I've certainly been finding that adjusters have been able to deal with expenses in a more timely fashion under COVID-19 than they were prior to that. Stacey, maybe we can talk a little bit about, reporting. It came up in one of our previous webinars, but I think it's an important point to talk about. How should healthcare practitioners report on the effects of COVID-19 and how the clients are coping in this circumstance?
Well, and that is a great point, and it's really important. I've seen it in a few reports that came in sort of in the early stages of COVID, and we don't want the reporting to be phrased in a way that it makes it sound like it's the COVID is the issue. We have to remember that, especially our clients with the psychological impairments, the severe psychological impairments, the brain injuries, that those are the impairments that they had before COVID set in, that is going to make it even more difficult for them to deal with the issues that are now arising as a result of COVID. And I think especially more so as time goes on, the stay-in-place order is still active. We're still limited to groups of no more than 5 people gathering. And I found that a lot of clients are really struggling. I was actually talking to one of my clients yesterday. She lives by herself, and she's got some psychological impairments, but certainly not to the severe level before COVID. But now, I spent half an hour on the phone with her, and she was crying, the whole time. So it was very, very obvious that there was a deterioration in her psychological state as a result of the social isolation. And then I had to question, if it wasn't for her injury impairments, would she be in the same state that she's in now? So I think that's the way we have to look at it when we're reporting.
Yeah, and I agree with that. And I know that from speaking to various adjusters, all of the adjusters that I've spoken to are very interested in hearing about deterioration in a client's condition because of the current situation that we're in. They want to know about that. They want to know how the person is coping. As we've said in previous webinars, you really don't need to distinguish between is this COVID related or is it related to their injury? It's really an issue of their coping mechanism. And, these are the life circumstances that we now face and that our clients face. And if they're having difficulty coping with them, it's no different than any other challenge that they might be facing. They're just having a difficult time coping with the current circumstances. So adjusters certainly need to hear about that. There's always this cost issue. Let's face it, not all adjusters are going to be open to additional reporting or approve for additional reporting. But I've found that most adjusters understand that in these circumstances, they have to be a little bit more flexible. I've not experienced adjusters denying further reporting or additional reporting because, as I said, they actually wanted it themselves to help document their file and show that they're working and that things are moving forward. So yeah, it's a discussion that you have to have with the insurer. I think Stacey's point initially was important, though. You can't just start, sending additional reports and expecting that for them. You need to have that discussion and get some direction from the adjuster in advance so that you know what they're expecting and they approve any additional reporting that you might be doing. Stacey, the other thing we wanted to talk a little bit about was the importance of documentation by the healthcare practitioners in their own file, not necessarily just for reporting to the adjusters, but documenting the current condition of their clients so that we have documentation for further use in the case as we're going along. And maybe you want to touch on that for a second.
Yeah, and that's really important, right? Is what's going into your clinical notes and records. Keep in mind that, part of this will be setting up the file. So when you do start doing more in-person treatments, there may be certain clients who have a need for increased treatment, right? Especially the ones who haven't been responding well to virtual therapy, or the ones who just have refused to do it because either they can't cope or they don't have the technology to do it. So you'll likely start seeing, as things open up more, you're going to have clients who are going to have a need for increased treatment. And so having that documented in your clinical notes and records during the COVID period will be helpful in terms of supporting that recommendation to the adjuster. The other thing to keep in mind as well, where you have a family situation where you've got parents who perhaps are now, the primary PSW for a brain injured child, or a spouse, you're going to find that the family members are taking on more responsibility. There's going to be more evidence of caregiver burnout, as well as all of this helps in two perspectives. One is on the CAT side, right? If we're looking at bringing a CAT application, we know under either the GOSI or even the mental behavioral at the 2-year mark, one of the things that is going to be looked at is the impact of the impairments on relationships. So if you've got a parent or a spouse who stepped in as a caregiver during this time because they're not working and the PSWs aren't coming in, then there may be some very valuable information that you want to start collecting.
And,
Glenn?
one thing to remember is that, through this experience, and this comes from speaking with some healthcare providers, we found that some of our clients have actually done very well operating under this system, that they actually prefer sort of the treatment sessions over the computer as opposed to live sessions. They find it more convenient. So this may be an approach for certain clients on a go-forward basis. Insurers will probably like it because it's probably less expensive. There's not the travel time associated with that. So that's something to think about. One of the participants this morning commented that we have to remember that the cost of additional reporting comes out of the client's limits, and that's a very valid point. So we have to think about that, and that's why it's important to talk to the adjuster about how much reporting they want and whether that's a cost-efficient way of doing things, because it does come out of the client's limits. So we do have to think about that when we're thinking about additional reporting. But I think that, because everybody's isolated at this point, adjusters are struggling as much as we are with knowing what is going on. And it's all a question of having the best information that they can about how all of our clients are doing. And they're really struggling. It's a repeated theme with every adjuster that I've talked to, that they feel that they are having difficulty keeping on top of what's going on with their various claims and the claimants because of what's going on with COVID-19. So I just think that more so than ever, open communication is really critical during this time period. And if you have problems with an adjuster not agreeing to allow you to report or saying, oh, I don't want to hear about this, then I think you've got to speak to the lawyer on the file and try to come up with an approach so that we have proper documentation. Just because the insurer says that they may not want additional reporting doesn't mean that the lawyer may not want additional reporting. So there, on most of these cases, there's two cases going on. There's the accident benefit side and there's the tort side. So from the tort perspective, these type of things that we're talking about, deterioration in condition, additional treatment that a person may need once we come out of COVID-19, these are all going to be very important things to be documented. And I would suspect that many lawyers are going to be asking for updated reports to comment on our clients' experience going through the COVID-19 situation. Stacey, anything you want to add on that part?
No, I think, you make a couple really good points, Len. And the one thing I thought of was that when we talk about reporting, right, we automatically assume that we want this formal report done. And so when you're dealing with the adjusters, maybe think a little bit outside the box, and maybe it'll just be a quick email to them saying, you know what, I met with, Jane Smith, or I did a quick video session with Jane Smith, and I just noted that these are the issues that she's really struggling with. And just send it off in a quick email. That way it's less of a burden on the client's med rehab funds, because you're not spending the time doing a complete formal report. And Len's right, you talk to the lawyer, because when the lawyer, at least I know what I do and what Len does and Matt, when we want a formal updated report, there'll be times where we ask you to do it, for the tort purposes. We fund the report. It's an assessable disbursement on the tort claim. It has dual purpose because we can still use it to rely on it in the AB action, but it's just a way of preserving those very valuable and sometimes very limited med rehab funds. So speaking to the adjuster, speaking to the lawyer.
Yeah, and I think that you have to remember that, let's take attendant care as an example, because Stacey made a good point. Because of COVID-19, a lot of family members have had to step up and provide attendant care where professional caregivers aren't able to do it because they're not allowed to come into the house. Now, they may not be able to recover their attendant care on the accident benefit side because they may not be able to establish an economic loss, or the adjuster may say, well, you're not working because of COVID-19. It's not a situation where a family member is not working to help provide the care. But there's still a tort claim in a lot of these cases. So even if we can't collect the accident benefits for attendant care, we can usually include it as part of the tort claim. So it's important to document these type of changes where family members are now having to step up and provide more attendant care, or even if it's a situation where there is a professional caregiver, but because of the COVID-19 situation, a person needs actually more attendant care to help them cope with the isolation and with the difficulty of being in this situation. That's something usually that we can incorporate into our claim in tort. And so it's important that that be documented, and the lawyers will generally ask the healthcare providers for a report on that when it comes time to getting a report and talking about settlement. The other thing that I would say is that I've been finding through the COVID-19 situation that where we're trying to discuss settlement of a claim, very frequently we're going to the treatment providers right now and asking for an update to comment on how things are going, whether our clients are having difficulty dealing with this situation, because that may be an indication of how things are going to be in the future, that this person does have difficulty coping with changes in their life circumstances. Now, obviously, this is a major dramatic change for everybody, but to me, it's just an example of another stressor in life. And if our clients are having difficulty coping with those type of things, that's an important piece of information for me to use, certainly when I'm talking about settlement of the claim.
Yeah, definitely. And
go ahead.
Sorry, just quickly to circle back on the attendant care piece. We have had some success, and again, it depends on the adjuster, and I think everybody who's listening will agree that we've seen a lot of inconsistency from adjuster to adjuster on a lot of different topics. Having said that, we have been successful in some cases where we've got a client who has high attendant care needs. The PSW is no longer coming in, and we've been able to discuss and get the adjuster to pay the attendant care to the family member who is now providing the care during COVID. So there are ways to do it. It's like I said, a lot of it depends on the adjuster, and I think a lot of it depends on the severity of the case. We may not see it happening in cases where injuries are perhaps less required. Basic supervisory care may not get you the full $6,000 a month paid to a family member, but if you've got a real case where, the PSW was coming in and assisting with meds, assisting with transfers, the bathing, the showering, all of that stuff, and now a parent or a spouse is doing it, talk to the lawyer. There may be some opportunities to negotiate with the adjuster to get an attendant care benefit paid to that family member.
Now, as things are slowly opening up, one of our participants was asking about what happens where a client doesn't want somebody coming into their house to do an assessment because they don't feel it's safe right now. And, you know, it's a very valid point. And I can tell you that, you know, I've had some clients who have said exactly that they don't want people coming into their home right now. And it's required me to, you know, speak with the adjuster and either get the appointment, if it was an insurer examination, to have it put off for another time, or alternatively make some type of arrangement. In one case, I know we've had an assessment done outside of the home in a neutral location where the client felt it was okay to go and speak to somebody at an appropriate distance. It was done in a park as opposed to in their home because they didn't want somebody coming into their house. So, you know, every situation is different and it's hard to come up with a general rule. Can a client say no? I would say at this point, because we still are under the emergency order and because people still have concerns about safety, I think that clients can refuse to have people come into their house, and it really is going to be up to counsel to speak with the adjuster if that, you know, is a problem, and try to work something out for an IE in the future. Personally, I haven't had any difficulty at this point getting insurers examinations rescheduled when a client doesn't feel comfortable with somebody coming into the house. I've never had an insurer say, no, it's happening, we don't care, we're sending them in. I mean, frankly, the client doesn't have to open the door. So if they don't feel safe having somebody come into their house, I think that's a legitimate reason right now to say, no, this has to be arranged at a different time.
You know, Len, that leads to an
Stacey,
interesting... Oh, sorry. It leads to a bit of an interesting point. I was talking to a few OTs about what's going to happen when the in-home visits start to ramp up. And one of the questions that came up, actually, that I noticed from our last webinar as well, is what about funding the cost of PPE? And it's a bit of a two-pronged question, and adjusters, again, are being inconsistent on the position that they're taking, because on one hand, you've got the PPE that the occupational therapist will want to have, right? The masks and the gloves. But if you're an OT and you're going into a client's home, should the adjuster be funding the cost of PPE for the client? Should that be considered a med rehab benefit, part of the med rehab benefit? And the information that I've gathered so far is that adjusters are being very inconsistent on this. Some of them are saying, look at, you know, from an OT perspective, your PPE is your own cost of doing business. And I can appreciate that it's not a normal cost of doing business, but the adjusters are questioning, why should we be funding the cost of your mask and your gloves to go into, you know, Stacey's client's home? On the other hand, you know, if I'm the client and I want, and I've got somebody coming into my home, am I going to want to have a mask and gloves on?
Stacey, that brings up...
Yeah, yep. Go ahead, Matt.
Sorry, I was just going to say, in line with what Stacey's saying, we've seen a couple of great comments about what are the actual rights of the client to refuse people coming into the home, especially for assessment. If we see, for example, assessments are being conducted in person on the plaintiff or our side in terms of proving our injuries, can we then go ahead and say that they're not allowed to have in person to make sure that we have a tit for tat, so to speak? And what are the actual rights of the person in denying anyone into their home during this time?
Well, you know, look, I think it's more difficult if the client is doing in-person assessments at the request of their own counsel. It becomes very difficult to deny that when the insurer wants to do an in-person assessment. I think you have to be consistent in that regard. So, you know, but if the client doesn't want to have any assessments, or if some of the doctors that the lawyer has set up assessments with, or healthcare practitioners that they've set up assessments with, if the client isn't comfortable with them, even if they're being set up by their own counsel, and I think it's consistent that if the insurer wants to do an assessment, they take the same position. But I don't think you can sort of suck and blow on that issue. Like if you're allowing in-home assessment that your counsel or that your representative has arranged, it's going to be very difficult to deny the insurer coming into your home or arranging their assessment. The difficult part at this point is I think there are a lot of assessors out there that are still not prepared to do assessments, even in their own clinics. They just are not, they're not happy doing them virtually because they feel that they're missing a lot of information, and they're not at the point where they're prepared to do assessments in their clinics yet. And this is an evolving situation, and we're going to have to sort of go with it as it evolves. But it's difficult. There's no simple answer to this. I think every case carries its own particular set of facts, and you've got to work with what does your client want, what are the healthcare practitioners prepared to do, and what are the assessors prepared to do. And it just sort of underscores what we've been saying all along, which is communication is even more important than ever in these circumstances, because anybody who doesn't appreciate that we're in very unique times here, I think is living on a different planet. And I think that our courts and adjudicators at the LAT certainly have already tipped their hands to indicate that they appreciate that these are unique circumstances, and they're not going to hold it against people that things are being done in a different way. We've already had a couple of court decisions, not specifically related to care, but to the actual practice of law, which have said, look, we got to get with the current times. These are unusual circumstances. Things are happening remotely because that's the only way that they can happen. And the court says, they're not going to tolerate people using that as, a way to try to take advantage of situations. And they're not going to allow plaintiffs to be, to be hurt by the current situation that we're in because things are being done in a different way. So, I think that's a good sign. It's a good sign that the courts and the LAT adjudicators appreciate what's going on, and they're going to try to be fair, and they're going to not try to hold the situation against clients if they can't do in-person assessments, and they're not going to hold it against them if they refuse to have people come into their home if they don't feel safe.
Yeah. And I agree with Len. Things are changing rapidly. I know there was a recent directive that came out a couple of days ago from the Occupational Therapy College, just talking about, starting to plan for going back into doing in-home assessments, and, talking about the screening, the checklist, the personal health assessment, and, certainly from the way I read it, recommending that, if you are going back into the home, that it's a slow process, right? It's not going to be a charge to the door where all of a sudden things are going to pick up and go from where they were. And I think Len's suggestion, especially with the weather getting nicer, if you can start meeting clients in a park or, somewhere outside of their home environment, then that may make them a little bit more comfortable if you feel it necessary to have an in-home assessment, perhaps for some urgent reasons. But we're going to see it change. It's going to change absolutely every day as this thing continues. And it's hard to predict where we're going to be even a month from now. But I agree that, creativity, thinking outside the box, perhaps doing things a little bit out of the ordinary, and having a bit of, understanding of the challenges that people are facing on all sides. One of the things that I've found in dealing with adjusters is that I can be talking to them now and they're at home and I hear their kids in the background, I hear their dogs in the background, and we just start finding this common ground where we can just start talking about life and things that are going on. And it really does help the relationship. Right? And that's important to keep in mind as well. They are people on the other side of these files. And if you can start working and building the relationship with them, then it becomes a little bit less adversarial. And sometimes we're finding they're getting a little bit more willing to do things a little bit more creative and outside of their boxes as well.
And the last point that I would make in regard to what Stacey was just saying, I've certainly been finding that as healthcare providers are becoming more creative in the way that they're providing service, it often leads to, different equipment needs, leads to, different types of software or different types of things that they've been using with clients. And I've certainly been seeing more treatment plans for different type of equipment and computer devices or computer software to help clients. And, I like that. I like to see that, these things are, that healthcare providers are trying to make the best of a very difficult situation. And again, I really haven't seen a lot of difficulty with insurers. I know that we've heard reports from various people that insurers are denying this and they're denying that and they're being difficult. My experience at least has been that that's the exception rather than the rule. I've been finding that most insurers are quite willing to work with us and try to make sure that our clients are continuing to get proper care and treatment. And it'll be interesting to see. I'm looking forward to a situation where if there's been, for instance, attendant care that's been provided by a family member and the insurer has denied that, I'm looking forward to taking one of those type of cases to the LAT and getting a decision from the LAT, because I think that we'll get a very positive decision from the LAT or from the courts on these sort of issues. So, I think that an insurer being difficult over these issues is not really going to play out very well for them in the long run.
No. And as Len had said previously, right, the information that you're gathering, whether it's in your clinical notes and records or in your reports, forms the foundation of the evidence in our tort claim. So even though it's something that an adjuster, may not be approving, or we find, especially like with, for example, housekeeping, people will say to me, but it's non-cat, they don't get housekeeping. But, we get it on the tort side. So just remember that just because an adjuster may be bullish or may, not be supportive of a recommendation, don't forget to include that in your report. Don't keep that information out, right? It's so important that it goes in for all sides.
And I think that, for those cases where insurers have denied, either equipment or they've denied attendant care being provided by family members because professional caregivers can't go in, those are the times where documentation is most important, because we will have to go and fight about those things at the LAT or in front of a court at some point. And so having documentation of the way the person was deteriorating without that type of care, how they improved when they had a family member providing that care that couldn't be provided by a professional caregiver, all of that information is going to be very valuable evidence for us to be able to recover those if we have to go to a hearing. So I think on that point, we're probably at the end of this session. Thank you all again for attending and for participating in the series of webinars. As Mark says, we're planning on trying to make this a regular event through our firm, and you'll be seeing other people other than just Stacey, myself, and Matt talking about various issues. We encourage you, if there are issues that you're encountering, please send us an email. Let us know what you'd like to hear about or problems that you're encountering, and we'll try to include these in our ongoing webinars from week to week. And all I can say is, again, stay healthy, stay safe. Hopefully we're going to be seeing you all again soon.
Yep, and I echo
Stacey?
Len's thoughts. Again, everyone, thank you so much for taking your time to be here. I can, speaking for the three of us, Len, Matt, and I have had a great time doing this. We love your comments and suggestions. Like I said in previous times, it gives us an indication as to what else is going on outside of our own little world. And, I echo Len, if you guys have any questions whatsoever, I had an OT give me a call a couple days ago on a file that I'm not on, but she just had a general question, and I took the time to talk to her. So if you guys have questions, if you have difficulties, future things you want to see us talk about, please send us an email, pick up the phone. We're always here to chat.
Yes, thank you all. And
everyone.
sorry, just to let someone know, these recordings will be made available if you were late to arrive.
Yes, everyone who's registered for these seminars, we will be sending you a copy of the actual recording. And as we've been doing in the past, we couldn't get to all of the questions, but we'll try to compile those questions into an information circular that we'll be sending out to everyone who's registered as well. All right, so take care, everyone. Stay safe. Have a great weekend, and we'll see you soon. Take care. Bye-bye.
Bye.